Right. Hello, everyone. Good
Welcome.
afternoon. Thank you all for joining us. So, just by way of introduction, my name's Robin. I look after the residential lettings teams here at Sandersons, and I'm joined this afternoon by my colleague Pippa.
Hi, I'm Pippa. I've been with Sandersons for 15 and a half years, so I saw a few long-standing landlords on the attendee list who will probably remember me from when I was first involved in property management, still very much involved here at Sandersons and helping with the overall day-to-day running and operations. So looking forward to telling everyone a bit more about the Renters' Rights Bill that we've been reading up on thoroughly as of late.
Which segues us quite well into what are we here for this afternoon? So it is the government's Renters' Rights Bill, formerly the Conservative government's Renters' Reform Bill. And what we wanted to do is speak with our landlords and other landlords and anyone interested really about what is it, what are the changes, why are they doing it, what are they trying to achieve, and what do we think they're going to achieve? And we're going to go over it this afternoon. It will hopefully come in at about an hour long. We've had a few questions in advance, which I think one of them we're going to address as we go because it fit quite nicely in with what we were talking about. And then the rest of them we're going to do at the end as a little bit of a Q&A session. If anyone has any questions that come up during our presentation, across the top of the screen, you'll find a Q&A button, and you'll be able to put any of those questions over to us through that way. Depending on where we are, we might be able to answer it as we go, or we might come to it at the end of the presentation and go from there. So this afternoon, on our agenda, as you can see there, we'll move on to introductions, the introduction of it and why. So it's a big one. It's a big one. I think it's fair to say it's probably the largest change since the Housing Act, the 1988 Housing Act. It will remove some of the standard ways of operating that we all know of, both as agents and as landlords. And it was there's been if you were up to date on the reform bill before the changing government, Labour have come in and effectively carried that forward and added some bits to it as well. I think as a bill, it's 20% longer than what the Conservative government was proposing. I think the main thing is, and hopefully this will be a running theme of the presentation, if you are here and if you're a landlord, don't panic. So just being aware of the changes that are coming and staying on top of what these proposed changes are and how they might impact you and keeping it in your mind a little bit is probably all you really need to do at this stage. Just hopefully keep listening to us. And hopefully what we say is going to be quite useful. So where are we at the moment? As of, well, today, or yesterday, really, Parliament has reconvened after their Easter holidays, and it's at what's called the committee stage, and this is a line-by-line reading and debate about any amendments, about any wording, about any clauses. They reconvened firstly on the 22nd, they sat again on the 24th, they sat again yesterday on the 28th, and they're scheduled to sit again next month on the 6th, the 12th, and the 14th. Those dates should be final, but each scheduled meeting could last for up to 8 days and postpone the later ones. But the reality is that there is a lot of willpower to get this through. I think the current industry thinking is summer. We're going to start seeing this become royal, or be granted royal assent, become a law in summer and be implemented towards the end of the year, October at the earliest is what everyone's thinking. Depending on how the rest of this year shakes out, it might even push through into next year. But not something to be betting on, I think. As an example, up until the start of yesterday's sitting, they had agreed clauses 1 to 11, and that was across 2 days of discussing it. So there's only 71 more pages worth of clauses to go before they've agreed this part of it.
Yeah. It's bedtime reading, but you can see online all of the challenges that have been raised. Some of them quite fair points, but it does seem to still be continuing in the direction with very little to challenge it. Labour do have such a big majority. It's unlikely things are going to change. So everything that we say today is with some confidence, but there could be things that are changed during this committee stage process. So I'll sort of step in and start to cover off some of the kind of key changes of the bill, which I'll just highlight them now, then we will go through them all in a little bit more detail. So the first and one of the biggest ones is that all fixed term assured short hold tenancies will be replaced with monthly periodic tenancies. So that doesn't impact anything that's not under the Housing Act, like company let tenancies, that's for all ASTs. Abolition of Section 21 no fault evictions. So that's where you can currently serve 2 months notice to end a fixed term or within a statutory periodic tenancy. That will be coming to an end as a means of regaining possession of your property. They are, however, expanding the grounds for possession within Section 8. So that's where there's mandatory and discretionary grounds. There'll be some new grounds being introduced to help make it give other options for landlords to regain possession. They also intend to end rental bidding wars, which basically means you cannot accept an offer above the rent that is advertised for a property. Whatever it's marketed at and listed at is the final amount. I think it's perhaps a bigger thing in London, where there's much higher demand for smaller properties. People do end up bidding over and over and over, and it kind of keeps going. So they want to put an end to that. And also rent increases are to be limited to once in a 12-month period. They're recognising
I think noticing on that, it's worth pointing out that's not really much of a change, but what they're doing is they're removing some uncertainties in how rent has increased. And so you can't write in a clause that says what you want. It's just they're saying this is how it's done. Once per year, you do a Section 13. That is it. Done.
Yeah. Absolutely. And I think just recognising in general that people are staying in rental properties for longer, making them a longer term family home, and actually tenants, if they would like to have a pet, they should have more freedom to do that, and it will not be refused without any good reason. From a sort of admin point of view, they're looking to introduce a compliance database, which all landlords will need to be members of, and also an ombudsman scheme. So at the moment, agents like us have to be members of an ombudsman that people can complain to. They're looking to introduce exactly the same, whereby individual landlords need to register with that ombudsman service. They're also decent home standards and AWAB's law, which is initially part of the Social Housing Act and sector, is looking to be extended into the private rental sector, and also looking to have a ban on any form of tenant discrimination. So sometimes you might see listings that advertise no DSS, no children. It will actually become illegal to actually put that on a property listing. You can't discriminate against any groups of people, but we let everyone who contacts us anyway for a property. So we'll go through that in a bit more detail later and how that will impact us. And finally, this is an amendment that has come through since the Act was first proposed. That they are making upfront rent a prohibited payment, which means that you just can't take anything which exceeds 1 month and as a deposit, and also as a holding charge, and then moving forward throughout the tenancy, 1 month only for the rent. Obviously the deposit can be taken at the start, but you can't take, say, 6 months rent up front or 12 months rent up front, which could have a bit of an impact on the way some things are done in some tenants. So we'll
I think on that topic as well, it's worth highlighting that you can still agree things, you just can't, it's not a contractual agreement that you can enforce, and we'll get onto I think later on we'll talk about what impacts that might have to you as a landlord in choosing your tenants. But there's a few of these changes where they come up where we're talking about statutory notice periods and whatnot. That doesn't mean you can't still have a good relationship with your tenant and come to an agreement otherwise, and that'll be a running theme about what we do going forward.
Yeah, absolutely. So moving on to look at sort of the more specific details under each of those kind of headline changes we've just gone through. So all assured short hold tenancies becoming assured periodic tenancies literally will happen pretty much overnight. So you may have had a 12-month tenancy, and then after that, it's automatically just lapsed onto a rolling month-to-month contract. That's kind of what automatically happens if no agreement is made to renew on a fixed term. Any fixed term tenancy will literally change overnight on whatever date it is. So you might be in a position where you're currently negotiating a renewal for 12 months, 6 months, or even 2 years on a fixed term or longer. And that will all change likely immediately. So, and that applies for any new tenancy as well. So any tenancy that we then were advertising the property for, that will be advertised with just a rolling periodic on all tenancies. I think the idea of this is just to give tenants a bit more freedom. If they move into a substandard property, they're not actually tied in for a full 12 months. They can actually go after. Well, I mean, effectively, they could give notice on day one if they wanted to, and leave on month 3. Whether that's in tenants' best interest, when it works the other way around for landlords being able to serve notice, there is a longer period, which we'll cover later. But whether that gives the right security of tenure for both parties is something that I think is being challenged quite regularly.
To touch on a point earlier as well, we're talking about those agreements that are being made now. That's not to say that they're worthless, though. You should still be signing those agreements.
Yeah,
both because while we all predict that this implementation date will be quick and will be soon on the scale of these things, you still need to be protected between now and then. And the grand change to that is the removal of the fixed term. The rest of the tenancy agreement still applies. Paying for bills, paying for tax, upkeep of the property, maintenance, reporting, access, all of these things. You still there's still value in those, and rent as well in particular.
Yeah, and I think it also sets an intention that actually, as a landlord, you want to let the property long term. I mean, I think in the majority of cases, all tenancies run smoothly, and it tends to be the tenant who's made a decision that they want to give notice and move on. So in a way, we'd kind of hope that quite a few tenancies would be largely unaffected. It will be a change to adapt to, but most who are already doing it well will be unaffected by that. The upfront rent becoming a prohibited payment, and it can only be charged monthly. That is going to be quite a significant change, I would say, and impact a lot of tenants. So where they're looking to make this whole bill something that makes it fairer for tenants, I think it's actually going to marginalise a lot of people who would otherwise be fantastic tenants who are perhaps relocating, and they have a job that they're still negotiating the contracts on, and they wouldn't yet pass referencing, moving from overseas. There's all sorts of reasons why people might have a break in employment, but actually have got savings, are in a good position.
Yeah, and could be really good tenants.
It could be really good tenants. Yeah, absolutely.
Yeah, so they're losing the option of covering that sort of temporary change of circumstances.
Yeah, yeah, absolutely. So so for tenancies in place at the moment, if you have accepted a tenant on the basis of 12 months rent up front, at the point of renewal, that can't be requested. Again, it can't be contractual. It can't be part of the tenancy that tenant has to pay 12 months rent again. There are options, though, around re-referencing, rent guarantee insurances, or for legal expenses, which we can touch on a bit more later on.
The next one. True.
Yeah, but that's where sort of having good ongoing relationships with the tenants, finding out the circumstances throughout, is really important if you're in a scenario where you do currently have a tenancy conditional on rent up front. And we think it's unlikely there's going to be any kind of transition period on this element of the bill. We think tenancies, existing and new, will literally become periodic overnight.
Yeah, which brings us swiftly on to the next slide, and the implications of doing so. Do you want to lead the way, Pip?
Yeah, so as I said, there's literally going to be just one set date where that comes into place. Sort of, as I said, I think the reason for it is that they're looking to stop tenants being tied into long fixed periods with substandard properties, and there's nothing that they can do about it. The landlords will have some accountability perhaps towards now with the local authorities, with the ombudsman and the database that we mentioned earlier. But ultimately, this is designed to give tenants more freedom, and there'll be no minimum for any fixed term, and a tenant can give 2 months' notice at any point to leave. So existing contracts are likely to need updating at some point, but we don't quite know what that looks like at this stage.
I think arguably it's fair to say that the bill, in that intention, the bill is doing what they said, what they want it to do. It is giving the freedom to the tenants. And I think that's the running theme of this bill, is it is giving more power to tenants. It will be successful on that one. I think we'll come on to it a little bit later. There's some sort of second and third order impacts of these changes that mean while a tenant can leave, who's to say there's something to leave to, as these restrictions impact the market in general. But it is definitely worth acknowledging that when it comes to ending the tenancy, the tenant is the one with the flexible option. The landlord is not, and that's the key. That's kind of the big impact of removing the Section 21.
Yeah, very much so.
So one of the other changes in it is around the rent, is around what we can advertise, what rents that can be accepted, and how rents can be increased. One of the large key points, and we touched on it earlier in the summary, is that they're getting rid of rent bidding. I'll hold my hand up and say at Sandersons here, it's not something we ever get involved in. If we pat ourselves on the back or blow our own trumpets, we like to think we're getting the rents correct, where our surveys of the markets and our understandings of what renters are looking for is accurate. So we're not putting it on the market super low, dealing with let's say 30 tenants that all want to say it, and approaching each of them and saying, well, give us your best and final. What rent would you pay to get more than this? And I think our record kind of speaks for itself on that front. I really do think this is one of those city-centric law changes. If we're being generous. And then and again, they're making a change to the section how you do rent increases. It doesn't really have an impact to our landlords. We kind of work in a process that's similar to what's being proposed in any case. But there is a big key in that one, is that at the moment, before this law passes, a tenant could challenge a rent increase at the first tier tribunal, and the tribunal could turn around and say, actually, what the landlord is asking for is under market rate, and I'm setting the rent higher. Now, the landlord gets more, the tenant has to pay more, which means the tenant is quite strongly disencouraged to going to the tribunal, because there's that risk that they could end up worse off. What's happening is they're changing that so that the tribunal cannot. They can either award what the landlord is asking for, or they can award what they believe market rates to be. Joined to that is, if you propose a rent increase and the tenant challenges it at the tribunal, the rent cannot increase until the tribunal has made their decision, and it cannot be retroactive. Those two changes combined mean that, strictly speaking, every tenant should challenge every rent increase, because it is entirely to their benefit. Because who knows how long that process will take.
It could buy them a bit more time until a tribunal has been able to make a decision, because it can't be backdated anyway.
Even if it becomes digitized, and we'll get into this later, even if it becomes digitized and the court order process is reformed, even if it buys you 4 weeks, it buys you 4 weeks of paying a lower rent. I think what I would suggest is there is no catch-all way around this. I think it's just very important that, as a landlord, either directly or through an agent, you maintain a good relationship with your tenants. And we go to them, as an example, if you're with us, we go to them and say, look, this is what market rate is, but the landlord's asking for this much instead. And you have that negotiation. And the way that you get a yes out of that is that you maintain a good property. You are responsive to tenant maintenance issues, and you have an agent that maintains that relationship with you. right? It's not helpful if someone moves in, reports a bunch of things, and that these issues are just silently closed or ignored. You want an agent that's going to pick up the phone and say,
Yeah.
hey, Mr. and Mrs. Tenant,
Yeah.
here's what we can do, here's what we can't do, here's why it's your responsibility, but thank you for reporting this. We're going to get on that sort of thing. So
Yeah.
it will become more complicated. It's not necessarily completely straightforward. And there is absolutely room for smart tenants to play the game, as it were. But
then on the other hand, I would say that what we've said about not being able to bid a rent above the advertised amount, generally you're going to find that rents are perhaps being advertised slightly higher than they traditionally would have been, because you want to allow for offers up to what that maximum could be. And then when you're looking at comparable rents on the market for reviewing a rent at renewal, I say renewal, the 12-month period that you're allowed to review it, because there's no sort of fixed term renewal, that actually you're perhaps going to be looking at that kind of ceiling rent, which overall, if they're your comparables, that is going to have an effect of driving rents up kind of across the board, which is perhaps something that they haven't really.
Well, yeah, I think it's a running theme of what we think the impact's going to be, right?
Yeah. Yeah.
So one of the other changes here again is you can advertise it as no pets accepted. You can at the moment, and you will be able to when the law passes. But the bill will be strengthening the rights of tenants to ask for pets, and it's going to enshrine a expectation that tenants can have pets, and it is up to the landlord to respond within 28 days. I might be 21 or 28 days to any request in writing as to why not. And obviously that is corollary to the landlord ombudsman, where a tenant can go and challenge that reasonable request. Again, it's just something many landlords are kind of open to it already, or that the property is not suitable for it, and it's the job of picking the right tenant, a tenant that's not in a position of wanting pets, not bringing one with them, or that discussion has been had beforehand. That said, they are strengthening some of the protections to landlords around it. They're adding in an accommodation that where a tenant gets a pet, the landlord can require that there is pet insurance or a pet insurance product, either that the tenant takes out and provides proof of, or that the landlord takes out and the tenant it will be a permitted payment to require the tenant to pay that policy.
Yeah. So they're amending the Tenant Fees Act of 2019 to allow that as a permitted payment effectively on top of the rent. I'll just add in, actually, at this point, we did have an advanced question from Sandy asking about if a freeholder charges a fee for pets, can that be passed on to a tenant?
So this one, I think I think Pip and we disagreed on the answer to this one a little bit. I think under the Tenant Fee Act, it provides a list of permitted payments, and all else is prohibited by default. And my understanding is the bill will change to allow pet insurance to be a permitted charge, which correlates to that means that a freeholder's charge for pets is not a pet insurance, therefore it is not permitted, and therefore it must be prohibited. That said,
I think if a landlord is going to incur an additional cost for a tenant to have a pet, I would say that is a reasonable reason to refuse a pet when a request comes in. But there's nothing to then say a tenant wouldn't come back and say, okay, well, if we pay the extra fee that's required under the lease, would you then allow us to get a pet? So I think
and then the objection
it's still a grey area what these sort of specifics of the Act will be, but as we interpret it at the moment, I would say there is room for negotiation on something like that. But if you've got a head lease that says no pets permitted at all, that will still
that will be a perfectly reasonable reason
in the head lease. If you've got a top floor flat with no outside space and the head lease says no pets, you're not going to be forced as a landlord to have to take in a large Great Dane or any dog, actually.
Exactly. It will still be a perfectly reasonable reason to why a pet is prohibited.
Yeah.
But moving on to the things that perhaps most landlords are here to know about. Section 21 abolishment.
Yeah. So again, just a quick summary of sort of the big changes to notices, and then we can look at them in a bit more detail. So the Section 21 is effectively being abolished for landlords as a means of regaining possession to prevent any arbitrary eviction. So that's if a tenant is sort of requesting lots of maintenance, or perhaps being seen as being a bit petty, and just annoying the landlord with kind of constant requests. There are circumstances where a landlord will say, "Oh, I'll serve them 2 months' notice, get possession of the property, and get another tenant." So I think there's a perception that is being used for landlords to get out of doing some maintenance, and I think every landlord who's on this call obviously cares and wouldn't get to that point. So I don't feel that this act is kind of targeting the right problem necessarily, but anyway, a decision is being made that the Section 21 should be abolished. So tenants can give a minimum of 2 months' notice at any point, and this has been amended as it's gone through, because initially it was 2 months in line with the rental period. So if you've just paid your rent, it will go to the end of the rental period, whereas now it's going to just be a straight 2 months. So if you serve on the 10th of the month, if the tenant serves on the 10th of the month, it'll end 2 months later on the 9th, rather than waiting until it's the end of a rental period. And the landlords will be required to give notice periods, which will vary depending on the ground that's being used. And they'll have to explain why the tenant is being asked to vacate the property. But they're also introducing some new grounds for if a landlord needs to sell or move back into the property. But it's just worth noting that they can't be used within the first 12 months of tenancy. So I think as a landlord, you just need to be absolutely certain that you are committing to the tenancy for a minimum of 12 months. That's not to say you can still sell the property with a tenancy agreement in place, but that tenancy forms part of the sale. So it can be sold to another investment landlord or someone who's prepared to allow that to run its course. So all notices will now be Section 8 notices citing one of either the mandatory or the discretionary grounds. Those are existing grounds that are in place. The most commonly used one is probably the one for rent arrears, which is a mandatory ground, but there are also discretionary grounds for the rent being consistently late, and then that's down to the court to decide.
Which is still kind of what is the case now. You serve it for rent arrears, and then you tack on these discretionary grounds for late rent payment or otherwise. What I think it's worth highlighting that Section 21s were often used as they were simply used as a catch-all. So whatever the reason the tenancy needed to come to end, whether that was rent arrears, antisocial behaviour, or damage to the property, or you wanted to sell, or you wanted to move back in, it was just industry accepted. It was simpler to serve a Section 21. Everyone knew what it was, how to do it, what the time period was. So it was just the default catch-all. The reason they're banning them is to get rid of vindictive evictions, as Pippa sort of mentioned earlier. So, a tenant wants reasonable maintenance, like running water or something like that, and the landlord, a rogue landlord in this situation, says, "No, just get out. I don't want to deal with it." And that person is forced to move through no fault of their own. And that was the idea behind them. The new grounds, the new Section 8 grounds, they do reasonably cover all the legitimate reasons for needing the property back, which is selling and moving in, and rent arrears or antisocial or damage, that sort of thing.
Yeah. So the antisocial behaviour ground doesn't actually have any notice period, but the court can't give possession any earlier than 14 days. So if they do agree it, 14 days is the period that they'll have. So just on the notice period at the moment, you can start proceedings once a tenant is 2 months in arrears. That is changing to 3 months in arrears. But effectively, once they're 2 months and a day in, they are they are 3 months late at that point. So you can start proceedings to get possession of the property. I mean, certainly the way that we operate with in-house client accounting and credit control, that's something that we would be onto straight away, trying to set up payment plans, trying to understand the circumstances, the issues, and try and work with the tenant to kind of recover any of those, because ultimately we do want to avoid going to court. We know it's a costly and very lengthy process, and we'd hope that's something we can avoid. So kind of for us, the in-house credit control is very robust, and we've got a good record of kind of being able to recover those. But I think the important thing, if you do have to go down the route of Section 8s, is that mistakes with the serving of those notices can be very costly. If it's not done correctly, courts can reject notices that are incorrect, the grounds are incorrect, the dates are wrong, and so it's actually very important to make sure that the right legal professionals are involved during that process. Or a preference really is to have a good rent guarantee and legal expenses cover in place as well, that covers the rent right to possession.
And it's particularly important as well if you are sorry, but it's just particularly important as well if that extension on Section 8, so it's gone from 2 months to 3 months, means that before you can even start thinking about proceedings, which will take X, Y, Z length of time, you've already lost 3 months of rent. If as a landlord that's not financially possible, well, that's definitely where you look at rent guarantee products, right? And you can bet that everyone in the industry is doing the same. And then the knock-on effect of that, as we all know, when costs go up, the rent goes up, because it's always looked to be shared in that manner.
And I think then the other thing we know is that the courts are already overstretched, and there hasn't really been much clarity on how the courts are going to cope with potentially more volume if cases get that far. It's also worth noting, though, that not everything will actually have to go to court for possession. I think there will be options. You can still have, if you've got a good relationship between landlord and tenant and agent, and that all works really well, you can actually have reasonable conversations. This is the landlord's circumstance. They perhaps need to move back into the property at some point or sell the property. You can have conversations to just mutually agree a tenancy agreement to come to an end. It doesn't have, not every single tenancy has to result in a Section 8 notice and court. So it's always a situation we'd like to avoid, but we'd definitely recommend sort of a rent guarantee, a legal expenses cover at this point. So we've got a bit of a quick example, haven't we, Robin, that we can show?
Yeah, it's I think the key thing here is right in the middle, that hearing wait time, and perhaps the bit above as well, where it's so 3 months pass, you've lost out on 3 months rent, and now you get to serve the notice. Depending on what notice you're serving, depends on how long it takes to expire. So 3 months rent arrears will be a 14-day notice period, and probably the one that you would use in that situation. And then the tenants fail to rectify that, and you apply to the courts for a hearing. The government guideline is 8 weeks. I'm not aware of any court that is meeting that. And the hearing wait time is dependent on what court you're applying to. Central London's actually really quick because there's a lot. It's got funding. They know that it's busy. Some of the smaller courts actually take even longer because they're not provisioned for it. But yeah, if you look as an example, it could take, and you can see there, it could take months. You have to be 3 months rent in arrears. You then serve 14-day notice. You then get to apply. Your hearing is 8 weeks later. The tenants fail to. You are awarded possession, and the tenants fail to leave. You have to wait 14 more days before you can go to the court for eviction orders. Once you've got the eviction order, you can then instruct bailiffs or enforcement officers, which will then be reliant on when they're available. But this is the worst case scenario. I think that's the thing to hesitate.
And it's not dissimilar to
Absolutely.
the situation at the moment, and hopefully landlords don't have to go through this. I think, you know, the point is that actually you just want to be really, really sure that at the start of the tenancy you're choosing the right tenant.
Yeah, exactly.
We can do everything we possibly can to do rigorous referencing checks, and make sure they're exactly who they say they are, they're in good employment, and also market the property well to get as many tenants as we possibly can interested in the property, so that actually as a landlord you have a choice of which tenant is likely to be most suitable. So we're actually only entering in to a tenancy confidently with the one who's most likely to be suitable for the long term. But we do know that circumstances can't change. We can't predict changes in health, financial circumstances, relationships, all those things that impact a tenant's ability to pay rent, or their behaviour in the property. So these insurances that are available are really robust and well worth having in place.
Yeah, definitely worth considering, and I think
Yeah.
definitely with the changes that are coming.
Yeah, and we have spoken to our rent guarantee provider about it as well, and there are certainly some options for landlords who don't currently have it in place, but do want to look at doing that. So a clear rental payment history for the past 12 months does allow you to actually put that in place, or you could do a legal only cover as well. So if anyone is interested in finding out whether they'd be eligible to put that in place, then do just get in touch with us as well, because that would be absolutely an option if you're concerned in any way. So moving on to the admin databases side of it, this is where we say that things are likely to take a bit longer. And sort of phased out with the rollout of this bill, because there's going to be quite a bit they've got to do some work.
Yeah, there's nothing at the moment.
Yeah,
they've got nothing. They don't even know what it might look like, let alone the final product.
No, I mean, I think for the ombudsman, it might be quite similar to the existing setup and process for agents. So as agents, we have to, by law, be members of an ombudsman service for both sales and lettings. It actually wasn't mandatory for lettings until only a few years ago, but we're voluntary members before that anyway. But they are making it mandatory for all landlords to join the scheme, and actually you can't market a property. We can't market a property unless that landlord is registered. So we will be prompted at the point we're listing on a portal to enter the landlord's reference number and the property reference number. So both of those can be found by a local authority or a tenant if they wish to make a direct complaint about a landlord. So yeah, I think that's catching the landlords, designed to catch the landlords who perhaps aren't currently using an agent, so the tenant can't complain about an agent, but they do have concerns about their landlord or their safety in the property, or the way they're being treated. It's giving them an option of someone that they can report that to. So
I think the intention of it is to catch rogue landlords. I think the reality is it's not going to. I think landlords that were ignoring the laws before this are going to continue to ignore the change in the law. But I think it's fair to say it's reducing the space in which those landlords can work, because there's, you know, all the professional services around letting. So advertising, Rightmove, On the Market, Zoopla, and similar, and all the referencing like Let Alliance or Good Lord, or insurance products like Vouch and HomeLet and all of these sort of things, they won't work. They won't be there for landlords who are not complying, who are not signed up with the ombudsman, and whose property is not listed on the database. That's not to mean that those landlords who are ignoring their issues won't find tenants. They will sadly take advantage of people who don't know better, who don't know their rights. But I think this is fair to say it will reduce the space that they can operate in.
Yeah.
So hopefully it may address some problems.
Yeah, and the database, which is a sort of another system, is being reduced to make it easier for local authorities to have a bit more power to communicate directly with the landlords. If there is an agent, find out who's managing the property and be able to contact that landlord about any concerns with the standard and condition of the property. We think it's likely compliance certificates need to be uploaded onto that as well. So there will be admin involved in maintaining those records and ensuring compliance on that. We anticipate, unfortunately for landlords, that it's likely that it's going to have to be a paid for scheme to cover their costs in setting up. But we hope that as agents we are able to take the management of that away from landlords, so that they've sort of got the confidence that everything is maintained and up to date as it should be.
Again, it's just an example of costs going up for landlords, which almost always have a direct impact in rents going up for tenants.
Yes, that will typically be reflected in the rent. So going back to whether they're achieving their goal of making it fairer rental sector for tenants is still, I think, to be debated. So yeah, that's where they're looking at with the compliance. But I think this might take a bit longer. I think the second one, the database, is partly for local authorities to raise extra funds as well around fines that they can issue for any non-compliance. So I think that's one of the reasons sort of why they're introducing.
Yeah, I think it's fair to describe this as probably more of a worry if you manage your own properties. It's another hoop for you to jump through. It's another part of your process, and maybe if you know, I do that thing that we're meant to be doing is say maybe it's another reason to involve an agent, just to take that responsibility away, take that tedium away. It might be just another thing in the pro column about making that choice. I think that's fair to say.
Yeah.
So property conditions and standards. So the Decent Home Standards has been added into what was the Conservative Renters Reform Bill into the new Labour Renters' Rights Bill. It applies in the social on the Social Housing Act to social housings. It was under consultation under the Conservative bill, and that consultation came back with some amendments to it, suggesting that you don't need to put minimum ages on, say, kitchens and bathrooms and things like that. But at the moment, we have no idea if Labour are going to pay attention to that consultation, take any of its advice, do their own, or just blanket make it apply to the whole thing. Again, it's one of those. If you are one of our landlords, I'm pretty confident in saying your property will be fine under the Decent Home Standards. Everyone that we send to a property knows about the Housing Health and Safety Risk, HHSRS, and every time you come and remarket with us, you'll have heard from someone in the team who says this is the rent that we think, and this is the work that we think you might want to consider, and the impact it will have on it. We're always trying to stay on top of maintaining the property, more than just worrying about the tenancy. We're also worrying about your asset, your property, your investment.
And the due diligence around the record keeping is also really critical, making sure that you can demonstrate that the tenant reported this particular maintenance, it was dealt with within this time frame, and this was the action taken, because you don't want to get further down the line and then the tenant uses that to their advantage and says, well, I reported this, and if as a landlord you've got no record of actually how you dealt with that and responded, something's likely to go in a tenant's favour. So, you know, we've got those systems in place to be able to record absolutely every step that's been taken at every point, and the timeframes for the worst case scenarios that something has to be challenged around that, because there's already something in place that means that you can't serve a Section 21 notice if there's any maintenance that's outstanding. So we've had those systems in place for a long time since that Deregulation Act came in. So this is kind of just adding on to it and perhaps expanding what's going to be covered.
Yeah, and I kind of sometimes think in that situation, almost more importantly, is if you ever do reach this point where you have to prove it, if you've involved us or another agent, then that admin of going back and collecting years worth of reports and sending it over becomes our problem. And I've spoken to so many landlords who made the change because they did have something go wrong and they had to rely on trying to find WhatsApp messages from a year ago, that sort of thing, as proof of they told me about it, I did something, and then they said, oh yeah, no, it's fine now. And that's just a massive amount of stress, headache and headache at a time when you're probably trying to turn your property around for the next set as well.
Yeah.
Touching briefly on that one, on Awab's law. So this is a law that was named after Awab Ishak, who passed away due to mold. He was a 2-year-old boy who died due to mold in his social housing. They will be extending that into the private rental sector. That has some very stringent requirements on how quickly you respond to serious health hazards and how quickly you take action. It's not yet deployed in social housing. Funnily enough, it's not due to come into force until October this year, which is about the same time the earliest we're expecting this bill to pass and come into force. So hopefully they do not decide to just blanket copy across, because that will cause a huge amount of upheaval on top of everything. But we are planning that they might. So no, because it's not even in social housing yet, it's still a untested bill in that untested law in that sense. The way in which you approach those issues is not settled and their best practices have not been worked out, but we are paying attention to it. We're reading what they do, what social housing landlord does. We're implementing similar processes just to be ready, just to ensure that if they do make it all happen all at once, that we're not caught out, which means hopefully our landlords won't be caught out. And then just to touch on one thing there, the rent repayment orders. The one thing that they've changed is if you are in breach of these conditions and of certain other conditions, a tenant can take you to court and be awarded rent that they have paid being returned to them. It used to be 12 months of rent that could be returned, and the tenant had up to 12 months to make that claim. That has been doubled on both sides of it. It is now 24 months of rent that can be claimed, and the tenant can have 24 months to apply for it, to take you to court over it. This does apply in those cases where you've evicted a tenant because you wanted to sell, or you wanted to move a tenant back in, and then you've put it on the market slightly too soon, or something's gone wrong in the process and it's gone on the market slightly too soon, and a tenant from 2 years ago that was evicted notices. It will be a breach of a very obvious mandatory ground, and they will get their rent back. So yeah, it just goes to say it's all about making sure you hit the admin, you do it properly, and not get caught out.
Yeah, absolutely.
So discrimination, again, it's a big talking point of the bill, but in reality, what it will do for you as a landlord and do for us as an agent, it doesn't really make much difference. They are strictly saying you cannot say no children and you cannot say no one in receipt of credit. You can't advertise for that way, and it can't be a reason to discount someone. We never considered it a reason to discount people. Every tenant's circumstances are taken into account, assessed individually, discussed with the landlord, discussed with the tenant. A really good example of this one is part of the decent home standards is a requirement to provide people with energy efficient properties. If you have a tenant right now who is in receipt of certain types of credit, you as a landlord could be eligible under the Green Home Grant for contributions towards boilers, insulation, and double glazing. If you didn't have a tenant in receipt of that credit, you would not get any of that assistance. So it's all about it. Yeah, it's never been a blanket no from us. So it doesn't really make any difference, at least in our process, at least in the way that we work.
Yeah. And I think the key with that is also around how you present and market the property at the start. If you only had one tenant who'd applied because you hadn't actually advertised the property particularly well, and the only person you've got is on benefits, then you wouldn't really be able to refuse them. Whereas if actually the property's been really well marketed and you've got a whole pool of tenants to choose from, as a landlord, there's nothing against you if you choose a tenant who's in a different circumstance. So that's about making sure that you've got as much choice as possible, and that's where we come in as an agent, doing everything we can with the marketing, the way we present our properties, we talk to people. All that is so critical at the start of the tenancy to make sure that that's done right.
Exactly. So on this, as sort of a brief little summary of the bill is what do we think what is the actual impact on the tenants? So the intention of this bill is to provide tenants more control, more surety, and a fairer market for them, a fairer rental market.
Yeah.
I think, like, to give a really quick summary, I don't think it's going to do that. I think the one thing that you can definitely say is tenants will have more control to end tenancies, and that is fair, and that is true. They will, at any time, for no reason required, be able to give 2 months' notice to say, that's it, we're moving out, off we go.
Yeah.
The
The timing of that could be inconvenient for a landlord, or the time of year. You might be just about to go on holiday, and then you suddenly realise that you've got to sort out a relet of tenancy and change of tenancy. But as an agent, that's something obviously we can manage anyway. But it's that sort of uncertainty around knowing exactly when that fixed term or something might come to an end. That will go. But I think from a tenant's point of view, if you're committing to a 12-month tenancy, you've got your kids settled into local schools, you've got family, to then find out that actually your tenancy has been switched to a periodic, and because 12 months has already passed and the landlord can serve 4 months notice, actually you've got less security than you initially thought you had. So I don't actually feel it is of any benefit to tenants in that scenario.
Yeah, it's the blanket getting rid of fixed term agreements, and their argument for it is if they allowed any wiggle room, then tenants would generally be forced to agree with what the landlord wants, because the landlord holds the thing that they want, and there's more demand for properties than there are demand for tenants. But yeah, as Pippa said, the corollary for that one is someone who previously had 3 years fixed term agreement now, and confidence and surety of what the rent is or what the rent increases might be, what the terms of the occupation are, and that 3 years of fixed term agreement where they can't be forced to leave, that's gone completely. And after the first 12 months of a new tenancy, the new discretionary grounds of wanting to sell or wanting to move back in can be given with 4 months' notice. So at best, people might have 4 months of surety each as it rolls, sort of thing. The other knock-on impact of this one is the bill. There's a lot of things in here for landlords to do, and there's a lot of things in here that are taking landlords to task, and putting costs on landlords and requirements on landlords. And as we saw in 2019, when that happens, when costs go on, then some landlords leave the market because either the timing's good for them or the timing's good enough that they're leaving, or it makes the cost, or it becomes too burdensome. And I think that's the industry belief at the moment, is that we're going to see a shrinking in the private rental sector, which is not what anyone wants. Really not what anyone wants, because for tenants, a robust private rental sector is really important. It gives mobility. It lets you move for work. It lets you move for family. It lets you move because you want to move, without having to run those calculations of, if I purchase and I have to sell in 2 years' time, am I going to lose out on lawyer fees and tax versus the income that the increase in asset value and the et cetera, et cetera, et cetera. So, and like adjacent to that is no one's predicting that the population's going down. So there's going to be an ever increasing number of people looking to rent or being in that situation where they want to move or need to move, and simultaneously landlords are exiting the building. The end result of that one is all of those factors are going to come together and rents are going to go up. And that's right, the current highlight of the industry, the thing that everyone's talking about, is the affordability cap, which is looking at the median wages for the area that your property is in to say, that is what's going to set the top end of the rent, because everyone is going to be forced to pay the most that they can afford to pay to get what they need, which is kind of a crazy way to approach things. I don't think it will go that far. I think what I'm hoping for is if you're a good landlord, if you're looking after your property now and you've got happy tenants and you receive rent, and everyone's okay, that will just continue. There will just be some extra admin, right? It's going to keep on keeping. And if you're a landlord that looks after yourself, you're going to have to expand your checklist of what you do and what you worry about. And if you're a landlord with an agent, we've done that.
Yeah.
We've done that already. So you
Yeah.
just keep on going, really.
Yeah. Yeah.
Right. Very briefly, because I've monologued too much on a couple of these points. Student tenancies, how is this affecting the student market in particular? Now, I understand this isn't for everyone, and potentially really only if you're a landlord in Canterbury if you're with us, but perhaps you've got investment properties elsewhere in the country. The government has acknowledged that student markets operate differently. Purpose-built student accommodation is exempt from this bill, which one might argue gives them an unfair market advantage, competitive advantage. I leave that to lawyers to discuss. If you are a landlord at the moment who has students in their properties and wants to continue in the student market, what this change means is with no fixed term agreement, you can't guarantee that you're going to get rent for certain periods. And because tenancies are joint and several, but they can give 2 months notice at any point, if one tenant says they're leaving, then that's it. The tenancy comes to an end, and you have to negotiate a new tenancy with any tenants that wish to remain. But if we sort of extrapolate that forward through the year, what if people fall out? And that's very common on student tenancies. What if people drop out of university and want to move back home, which is fairly common as well? Or what if people notice and realize that if they finish their exams in February, March, so they're on an earlier schedule, if they gave notice in January, they could just move back out and not have to pay the last few months of rent. Yeah, there isn't really a good answer to that one, I'm afraid. I think
it's a complicated one, isn't it?
Yeah, I think what it means is the student market. The student market it keeps the theme of the student market, which is over the last few years, it's becoming less and less and less of an enticing option.
We've had a lot of landlords transition, haven't we, from student into professional in Canterbury?
Yes.
So we've seen happening quite frequently.
Absolutely, and I think that's worth touching on in general. Is our tenancies our average length of our tenancies is over 3 years, and that's kind of the whole point of it. Is people don't like to move, so which is why we think that why we're trying to say that the theme of this webinar is don't panic, because yes, there's more regulation. Yes, there's some more hoops to jump through. Yes, the way that we have to work is going to change, and the timeframes that we look at and perhaps the horizon that we work off is shorter now, because we can't say for 12 months we've definitely got this sort of rent coming in or we've definitely got a tenancy. But that doesn't change the human reality of it, which is none of us like moving. Like it is painful. We do it when we have to, or we do it when we feel the need for that change, but we definitely don't do it every 3 months just because the law has given us this slight loophole in which we can choose to do so. Which I think actually I probably should have moved forward the step, which is the next step in preparing for the bills, and what should you be doing right now as a landlord? So first of all, I would say hopefully keep reading our newsletters, keep watching our walk and talks, and join our next webinars, because it's vital for us to stay on top of this one. And we will communicate with you. We will try and make sure you stay on top of it alongside us. That said, if there's things to think about right now, get a jump start on making sure you're fully compliant and you're aware of all your compliant things, what you need. And think about the tenant that you have at the moment. This is, I think, more particular for if you manage properties yourself, but even, if you've had some tenancies where you've thought, I'll just let that go because I could, if they really stop being good tenants, I can use a section 21 and I could find someone else, but I've decided not to because the expense, the time, the effort. You will lose that option. So think about it now. We will, sorry.
I was going to say, just visiting the properties regularly. I think that's something that's already happening for our managed landlords. But anyone who's not managed, we are happy to do a one-off visit to a non-managed property, and send over a report if you haven't managed to get there for a while. So that's absolutely something we can arrange sooner rather
I think the
than
key thing
later.
there as well is making sure it's a documented report.
Mm.
So photos, written description, signed by the tenant that they agree that that's a fair and accurate representation.
Yeah. And anything the tenant is responsible for as their obligations, might be condensation is kind of one of the bigger ones. Make sure that that tenant's been written to and that's communicated to them, and there's a record of that. It all helps if there are any problems further down the line. But if there are issues now, there is an option to serve that Section 21 notice if you need to. If you're on a periodic or a fixed term that's about to come to an end, that's absolutely, there is an option.
And there will be a live date on that one as well, sort of like a go date, a final cliff edge, which is once this gets royal assent, we will be told more about the implementation timeframe. At the moment, that's still what we've had is assurances from the government that a reasonable timeframe will be discussed with the industry and relevant stakeholders, and tenants, landlords, and agents will be educated on these changes. What that actually looks like, who knows? But really, just be thinking now, so that when you're asked that question, when we reach that cliff edge and the changes, we know what the date is, and you need to think, now or never, am I going to think about changing my tenant? Am I going to think about selling my property quickly, or am I thinking, what am I going to do with it? You know the answer to that one, and you're not panicking with a smaller time frame. Like it's not a bad thing to consider it right now.
Yeah, absolutely.
So Q&A.
We've gone over a little bit, but that's just because there's quite a lot to cover. Keep remembering other bits as we're going through.
So worth highlighting, we are recording this, and if you're here today, you will get a copy of it. And also, if you're not here today, if you've signed up and they've shown interest, you'll be receiving a copy of this to watch in the past. So obviously, we are overrunning a little bit. But if you do need to drop out, need to go elsewhere, there will be a recording. Especially if we haven't answered your question just yet.
Yeah, so do send in any questions if you'd like to. We had one or two in advance, which I think we've largely, hopefully, covered during the call. Robin, would you say?
I would say so, yeah. But I'll give them. I've got 1, 2, 3, 4, 5, 6. I've got 7 here, I think, and I'll just give them a quick hit. So, so do you think we'll see a higher turnover of tenants due to no fixed terms? No. On average, no, is the summary. Just touching on earlier, people, they move because they have to, not because they can, generally speaking. If you've got properties that you're not sure about, maybe they will see more turnover. But even properties that are, let's say, more suited to shorter tenancies, let's say city centres or ones where you would typically get a good example in Canterbury, Ashford, and Maidstone are ones that rotating or trainee doctors go through, which typically tends to be flats. They were moving anyway. They're not going to move any more just because they can. Right? It's going to be the same thing.
And I think many properties are also unfurnished. And I think there has been a concern raised that people are going to use this market for short-term and short lets, basically, which would make it cheaper than getting a holiday let or something. But I think they're generally unfurnished, so no one wants to move into something and the hassle of moving all the furniture in for something you're going to be in for that period of time. So I think that would be sort of largely unaffected in those cases.
Yeah, absolutely. From Tom, how long will the process take to get the house back if I want to move back in? The truthful answer is how long's a piece of string? There are too many factors going into that one for us to confidently say anything now.
If we had a scenario when you just started a tenancy, 12 months would have to pass on that tenancy before you can serve that notice move
Yes.
back in, where you could serve it in month 8 to take effect from month
Yes.
12.
The period of the notice cannot expire in the first 12 months, but you could serve it at 8, for it to expire on 12, for then you to seek possession the day after, 12 months and 1 day in. The other side of things is just to address that, I think we briefly touched it earlier, is you don't have to use a notice. You could talk to your tenant and come to an agreement. There's some familiar faces to those of us in the industry that have suggested, you can just pay the tenant to leave, which is true now. You could do that now if you wished. And that will still be true once this bill passes into law. It's just if you're relying on the notice, that's when the change has been made.
Yeah. And then however long, if they don't go at the point you've served that notice, then that's when you need to look down the court route to get possession. But we'd hope it wouldn't come to that if everything was being well managed all along the way. But that is the worst case scenario. We actually spoke to our rent guarantee providers the other day, and one of the things that they added on is that they had a scenario where a landlord was moving from overseas to come back into the property, and the tenant didn't actually leave at the date that they'd returned back to the UK, but the rent guarantee insurance covered their accommodation and storage costs for a month for that extra period of time while the possession was still pending. So those scenarios, it's actually really worth having that kind of thing in place.
Yeah, absolutely. Should landlords be concerned about possible fines? Is this something you as an agent will manage? Yes and yes. Like, no one wants to pay fines that they don't have to, and I think it's fair to say that none of these restrictions are restrictions that are new to us. It's new to how they're being managed and tracked, and how they're being recorded, and who has insight into these things. If the private rental database came into effect tomorrow, I can very confidently say I've got an entire portfolio of landlords that we would just simply do the business of putting them on. They are compliant. They are all above board. So that's definitely one aspect of this bill that I'm not concerned about in the slightest.
Yeah, and we effectively take on that liability. So next question, what should we be most concerned about, and how do you propose to manage this?
That is, why did we save that question? That's unfair on us.
I know. And I shouldn't have read that one out. It's I mean, I would say it depends. As I say, for landlords, it depends how they're currently managing the tenancy. I'd say if you're, well, you kind of touched on it earlier, Robin, if you're currently using a reputable agent, then you've kind of not got too much to worry about, as long as all the changes are being communicated to you and you know how it's going to change. If you need to get possession and anything else that will impact you, then I think there's not too much to worry about. If you are currently self-managing and maybe struggling to keep on top of all the compliance and legislation as it is, then maybe you have got a bit more to be concerned about, especially with the fines that are coming in. Would you agree, Robin?
Yeah, I'm not sure. I don't know what I would say that you need to be most concerned about, but I know how to manage it. Is that it's nothing that we don't already do. And as agents, it's our job to worry about how the law gets implemented and what hoops have to be jumped through at that point. Yeah. So and
it is complex, and it is forever changing. There is a lot to keep on top of.
Yeah, absolutely. We've got one from will the bill affect rents? I think I portrayed how I think about that quite clearly. Yes, they're going to go up, and they're going to go up to the limit of your local median income affordability. I think.
Yeah. And I think it will be in a way good for landlords in that respect. I think we maintain that property actually continues to be a brilliant investment. There's always going to be a demand for properties, and I think it's good for the long-term capital growth, but also in the short term, if the rents keep going up, that's still good for landlords. So
And then final question: what is the benefit to landlords? Refer to the answer to the previous question. I think the summary is there are no benefits within the law to the landlord. That is not what the law is designed for, or the proposed law. It is for the benefit of tenants, and solely for the benefit of tenants. But I think if you're here today and you're paying attention to these things, you are unlikely to be one of those landlords that the law is intending to curb or combat. So chances are your investment is mature. Your history as a landlord will continue. You might benefit from the rents going up. You might suffer from these fees being added in that you have to pay each year, or 6 months, or 24 months, or who knows what they decide to implement. But I think the long and short of it is it's not intended to benefit landlords. There might be some benefits to come out of it, but they are second and third order effects.
More supply and demand related.
Yeah.
We have just had a question in from Kate as well, saying, will there be grounds for eviction to carry out necessary works in order to comply with legislation, e.g. EPC increasing to a C? So for any landlords who don't know, that's the minimum energy standards, which is currently an E, but it is changing to a minimum C in 2028. For all new tenancies. But then for existing tenancies, you've got until 2030. In terms of being able to use that as a ground.
Yes. So there is a ground for it, ground 6. In actual fact, this is probably one of the biggest amendments that I think has been suggested as sensible, but unfortunately might not make it through the House of Lords. In social housing, the ground 6 is much more flexible for the landlord, or the equivalent. But the one being proposed in the Renters' Rights Bill is if you need to demolish or redevelop the property to the extent that the tenant cannot live there, you have a mandatory ground, which is ground 6. What the key on that one is if the tenant can live there, then you have to accommodate. And if you can work around them, but that will come down to what your contractor suggests and is willing to put into writing for you. Whether the tenant accepts that, if you have to defend yourself at the tribunal, you need to evidence that you can't reasonably expect the tenant to. The tenant can't reasonably expect to live there. You have to shut off electricity, shut off water, pull out a kitchen, whatever the case may be.
And that's partly they're also giving a bit more time for existing tenancies. Just on the minimum energy standards, that is, they're also at the same time reviewing the components of the EPC standards. So the legislation is, at the moment, it is the equivalent of a C, but they are also at the same time reviewing that process. We don't know what it will look like or how the reporting standards might change, but just kind of a heads up on that. But we'll continue to keep everyone informed. We did do a blog about it not long ago, but we will keep updates.
There was a white paper last month written at the behest of the government, and there is discussions about how to restructure how EPCs are calculated. But our recommendation is don't worry yet. Pay attention, keep hopefully listening to us. But big changes are coming to the EPC regulations next year, and that'll be the time to really drill down into what you can do and what you can't do. Whether you should get an EPC now if you can do it easily, or whether you should wait for the changes in how they're being calculated.
I think the consultation period on those minimum energy standards is actually open at the moment until the beginning of May, I think. So in one of our recent blogs, we published the links on where you can have your say around those changes. So that might be something that's worth looking at if anyone's interested. We digressed from the Renters' Rights Bill, but it is still an important topic. So thank you for that question.
And I think one last question is Ria's question about notice on the end of the property. Shall I just cover that off and say goodbye to everyone? So Ria asked, how much notice needs to be given if a landlord wants to sell or move back into the property? So the notice for those grounds is 4 months, but it cannot expire in the first 12 months of any tenancy. So if it's older than 12 months, say they've been in there for a couple of years on a periodic, you can serve it 4 months notice, after which they must vacate. If it's a new tenancy, you can serve it at month 8 to expire on month 12 plus 1 day, and then they have 4 months to go from there. All right.
Yeah, but you can't then re-advertise that property to let within 12 months.
Within 12 months of the expiry of the expiry of the notice. Sorry.
I think that's to cover it being a potential loophole that landlords might use to say they're going to sell or they're going to move back in. The tenant moves out, and then you say, "Oh, I couldn't sell," or "My plans changed." I think they're trying to prevent that from happening, which is why they put these rent repayment orders in at the moment. But again, we'll wait more updates on how that's all finalised.
Yeah. All right.
Seeing one more come in. Oh, Ray's replied saying thank you. You're welcome.
So I think that brings us to the end. We've overrun by about 20 minutes, but I think
there's a lot to cover.
I was going to say I budgeted for that, but in any case, thank you everyone who's come to this one, the first perhaps of many the webinars that we're running. We're really grateful to those of you who have come, and thank you for your questions. We hope this has been helpful to you. We hope this has been informative. If anything's come up that we haven't answered, or any other sort of questions that you just wanted to know some answers to, or to discuss with someone, feel free to give us a call, get in contact. However much you prefer, email, phone, all good, and we'll do our best to help. All right, so
thank you so much, everyone.
Let's do it. Right. Well, thanks. I hope everyone enjoys. It's a bit of a heat wave over here. So apologies to those of you going back to an office. But I hope it lasts through to the weekend. And have a good day.
Perfect. Thank you. Bye.